Welcome everyone to another session with the Purposeful Project. I'm BJ, the CEO here at Purposeful Project. As you guys know, we're currently going through a series of events, giving back to the community for free. This will be available to be replayed, and there will also be a subsequent blog article with all the gems that are shared. We are very excited to run our first legal session, as we all know that law, legal, numbers, the contracts, these are the things that sometimes entrepreneurs sometimes forget, or sometimes you go to in crisis mode. I'm very happy to pass on over to Daniel Walker, who will be leading this session. As always, if you have any questions, please put them through on the chat or send it to us via our Instagram DMs. We are in the background watching and supporting. I hope you guys have a great session. Peace. Over to you, Daniel.
Thanks very much to the Purposeful Project, and thanks for having us. Just for those of you who don't know who I am, my name's Daniel Walker, and I founded a platform called Zegal.com some years back in 2015 in Asia, and we help around 20,000 businesses now to basically get legal contracts done online, to do stuff which seems quite complicated, but we hope to make it as easy as possible. And we do that with the support of lots of amazing law firms. And we've just launched over here in the UK, and we're working with the fabulous 360 Law, who are here today to answer questions and to talk about topics startup related. So if I could start actually by just asking everyone to introduce themselves and what their speciality is. People think of lawyers as just being either kind of contract lawyers or criminal lawyers or business lawyers. So actually it gets a whole bunch more specialist than that. It's just a bit like going and seeing a doctor. You discover quite quickly that a doctor specializes in just one part of your nostril. And that's how we lawyers do it as well. So I'll start first with Bob, if that's okay, and then Bob can take you through and introduce you to the team over at 360 and explain how they work.
Yeah, hi, I'm Bob Taylor. I'm the CEO and General Counsel at 360 Law Group, which is a regulated and unregulated practice in the UK. We are now operating in 70 countries worldwide, and there's about 400 lawyers that now form part of that group. I'm a barrister by profession. I don't do very much law at all now. I suppose the easiest thing is that I used to do a lot of corporate law, but now I rely on people like Erika, who's probably going to talk next, to do head up the corporate law side of it in the UK.
Thank you, Bob. So I'm Erika Moralez-Perez, and as Bob has said, I work with him under the 360 Law Group. So I'm a corporate and commercial lawyer, which, unless you're a lawyer, means absolutely nothing. So what it does mean to the rest of the world is that I deal with business-related legal issues, and I support businesses in enabling them to use law and their legal contracts and that type of thing to make them more money. Shall I introduce the next person, Amanda?
Thanks, Erika. So I'm Amanda Williams. I also work in the 360 Law Group team, looking after the commercial contracts. So in a similar role to Erika, facilitating those contracts that you're going to have with your customers, but also not forgetting that you'll have contracts with suppliers, people that supply to you. And as you grow and get bigger, then you may be looking at contracts where you might be reselling other people's products. You may be looking at partnering with people. You may be looking at forming strategic alliances. So all of those contracts that facilitate you running your business and getting revenues and cash in the door. So they're the types of areas of the law that I can help and assist with. The other member of our team that we've got with us today is Mark. So Mark, can I hand over to you?
Thanks, Amanda. So I'm Mark Hall. I'm another lawyer with the 360 Law Group. And just to emphasize what Daniel has said, I'm another specialist. But as you'll hear as we talk through, there's often an overlap between commercial lawyers. So I am primarily a commercial lawyer, but I have some specializations in the automotive sector and IP, intellectual property. So where I can help, I hope, and I've done so in the past, is by helping companies, small and some very, very large companies, to get the value from their innovation. And I'm very excited to work with startups and SMEs because they're the bedrock of a lot of the innovation that goes on throughout the world. And the idea is that I, as a lawyer, help you as a companies to get the value from the IP you have, bring it to market, exploit it well, and sometimes use it as leverage to get capital, for instance. And again, that illustrates where there's an overlap between what I will talk about and what Amanda and Erika may talk about in terms of corporate strategy. So.
Good. Thank you very much, everybody. We are a little clearer, I'm sure. So what I'd like to do first of all is I've got a few questions myself for the panel, and if anybody on the webinar would like to ask specific questions, please don't include the name of your problem and counterparty and person that you want to sue in the question. Make it sound like it might be a fable rather than an actual piece of legal advice. But if you could please ping those across to me, and I'll try and also ask our talking heads about that. Let's kick off with some basic stuff. The topic of the seminar is making legal easy. And I think one of the first things when people think about law is how complicated it is, naturally. And that leads to us doing two things. Either we put our heads in the sand and we ignore it, or we go ahead and we make mistakes. So it would be great if you could perhaps take it in turns just to tell me and the team a few of the things that are obvious mistakes that happen, and please some actionable events that we could take to actually stop that from happening, because a mistake is only acceptable when it's made once, not when it's repeated. Whoever wants to go first, please, amongst yourselves.
Yeah, I agree. I mean, I start at the beginning, so I'm going to overlap over Erika here, really, because she's probably the expert in this area. But I mean, one of the first things to do when you go into business, and I've done it when we started 360 up 7 or 8 years ago, is to it's great having a good idea, but you've got to make sure that two things are happening. Number one, you've got the right vehicle that you're actually going into business with. Being a sole trader might not be the right vehicle because you might be exposing yourself to liability. Whereas you might be better off going through a limited company. So, I know that Erika's going to talk more on that. So you've got to get the foundation of how you're going to trade sorted out first. The next thing that's of really importance, and you need to do it cost effectively, and we all understand that, which is the reason that 360 was brought about, really, to provide lower cost legal services to SMEs right the way through now. And that is to actually make sure that the way you're trading, the contracts that you're trading on are solid. There's not holes in them. Your liability is protected so that you're not going to go out of business as soon as you do your first transaction. And I think that sort of initial advice is the stuff that everybody who's going into business needs to sort of understand and get into really, really quickly. I mean, there is specialist stuff that we need to consider, which Mark will go into on protecting your IP, but it's really making sure that your contracts reflect your services you're providing, your products you're providing, they're protecting your liability, which is the stuff that Amanda's been with us, who's been with us like 7 years now, I think, is very specialized at doing. So I'm going to hand over to Erika there, because you can do much more on that corporate role than I can now. Erika.
Thank you, Bob.
It's the last time you can hear me say that, but there you go. Yeah.
Well, this is being recorded, Bob, so we've got evidence. So that leads me, the point of evidence leads me quite nicely into the point I'd like to make, actually. There's a few points I'd like to make, just that segue really nicely into the vehicle that Bob has mentioned with regards to your trading vehicle and how you're going to trade. So however you're going to trade, it's really important to not only identify that up front, but then think about that, how that fits in with other members within your organization. So for example, you might have shareholders, you might have a business partner. We call them a business partner. In legal terms, we might call those a shareholder, depending on what vehicle you choose. The reason that I mention this is because it's really important to establish up front the relationship that you have with other potentially part owners or stakeholders of your business. Why it's important is that if you have a situation where you can't agree on something, you need a way to resolve that issue. And if you don't have a documented way of resolving that issue, the law may not be able to help you. So it's really key that you've got a way to get out of potentially gridlocked or deadlocked, as we call them, situations. So finding your vehicle is absolutely imperative. Establishing how you're going to work together as stakeholders within the business.
Please come back.
technical problems. Shall we switch to Mark and come back to Erika?
So I'll just carry on one thing there. I mean, Erika touched on it, and we'll wait for it. Hopefully she comes back on it. But I mean, also the vehicle that you're setting up determines on things that you might need down the road. You might, she's back now, so you might need funding on that vehicle. You may need to raise money, to take yourself onto that next step of your journey as a business. And going out as a self-employed person and going out as a sole trader is probably not the easiest way to start raising money, whereas going through a limited company where they can take a charge over the company is going to be a better way to actually raise funds. Back to you, Erika.
Thank you. Sorry about that. Technical problems. Never rely on technology. Rely on your lawyers instead. So the vehicle is really important, and you've got to establish how you're going to be working. Again, that's important for deadlock situations, but it's also important for raising funds. So you might be using different methods of fundraising. It might be through a bank. It might be through angel investors. It might be that your mum and dad are investing. The point is, you need to be really clear up front about how you're going to treat those people who are putting money into your business. And the way you do that is that you document it. Bob also mentioned cost, and it's in mind, because if you are fundraising, you will want to factor those costs in. But I can assure you that prevention is always better than cure. So investing up front in your legal infrastructure will save you lots and lots of thousands of pounds moving forward. And then finally, I'd just like to say that start as you mean to go on at all times. Behave today in your startup phase as if you were going to sell tomorrow, because by putting your foundations and your infrastructure in place will put you in incredible stead, not just for doing business, but if you do want to get investment or sell or scale. So always start as you mean to go on. Amanda, over to you.
Thank you, Erika.
Thanks, Erika. So lots of small businesses that we talk to shy away from contracts, and we often have the conversation with people that surely I can just do business on a handshake, and verbal contracts are legally binding, but actually proving what's been agreed after the event is very difficult. Sometimes your perception of what you thought you'd agreed is different from what the other side's perception is. Sometimes, your memory's not as good as you'd like it to be. And, it's fairly straightforward if you've just got one transaction that you're discussing. But we hope that actually you're going to have lots. And, a handful will lead to, a basket-full will lead to, many, many more. And trying to remember the specifics of each one for each specific customer engagement, can prove very, very difficult. So contracts are really important. People need to know what it is that they're going to do, what their obligations are. And we talk about the 5 Ps. We talk about, the product. So what is it you're buying and selling? Is it equipment? Is it licensing software? Is it some consultancy work? What is it? And we talk about the price. How much are you expecting them to pay? When are you expected to get paid? What's the mechanism for getting paid? We talk about the people. We talk about, who are the contracting parties? You can't actually sue somebody who's not a party to the contract. So it's really important to understand who's entering into that contractual relationship, because he who contracts pays. So again, if you're not getting paid, you need a mechanism for actually pursuing receipt of payment. We also need to look at, the place. So when and where are you going to deliver this equipment, provide these services? And we need to look at what we call penalties, just for the sake of, starting a word with the letter P, just to close the circle on this. But what are the consequences of not doing that? And, most of the time, all of these relationships are amicable and everything happens, nice and smoothly. But the challenge comes if there's a dispute. And it's the same with a relationship. It's all lovely in the honeymoon phase. But as soon as you start throwing pots and pans at each other, it's very difficult to sit down rationally and say, hang on, what did we actually say was going to happen? So let's agree it up front while we're all, looking at this from a very objective and positive perspective. And often for a lot of companies, the IPR, which Mark will talk about more, but the contracts around that form the asset base that creates the value that is your organization. So for a lot of organizations today, I'm very mindful of the fact that actually a lot of it is based on software, it's based on apps on your phone. There's not much tangible manufacturing product that's made in the UK anymore. And so that intellectual property and the value of those contracts is paramount importance to be able to evidence. It's of paramount importance to be able to protect, and it's in paramount of importance to actually get right, so that to the point that Bob made at the beginning, you are limiting your exposure, your liabilities, and controlling and containing your obligations so that you can ensure that those things are met. And, you know, we find that actually, you know, whilst it seems like a massive hill to climb at the beginning to get contracts in place, actually, you know, working with small businesses and looking at their suite of contracts is something that I've been doing as my day job now for more years than I would care to admit. And having template contracts, and I believe that you've got this facility through the Zegal application, is absolutely key. And we can assist with creating specific elements of those contracts to meet the requirements of your individual business needs. And we're also mindful of the fact that actually as small businesses, you may be looking to contract with organizations much, much larger than yourselves. And often they'll be looking to impose their terms and conditions on you. But actually don't be worried about that. Again, your template contracts, whilst you may not be able to push those in place of the third-party terms back on them, they act as a very, very useful checklist for all the things that you need to make sure that you're covering in that contract with that third party. And we see this many occasions, that big organizations try to take advantage of smaller organizations and miss out capping their liability, miss out protecting their IP, miss out some of the key important features of those contracts. And so it's a useful checklist, it's a useful vehicle to use, and it also shows that actually you've got a professional presence and a well-organized and structured business organization that you can where you can actually show that you've got template contracts in place. So all of those things, you know, negotiating those terms, redlining those terms, providing advice, as I say, are things that, you know, we do every day of the week. And so whilst it might seem like an enormous job when you look at it for the first time, you know, believe me, actually, you know, we see this day in, day out, and you know, it's a very, very common task that we get ourselves involved in, and something that we can help with relatively easily and quickly. I can go into specifics on that, but actually at this level of the conversation, I'm going to hand over to Mark now to talk about protecting your IP.
Just before Mark comes in on that, I just wanted to pick up on something before I actually forget it. Something that Erika said as well. I mean, you should be looking at the end of your process, the selling of your business, or to making your money out of it, getting an out, as we say, as you come into the business. So it's very, you know, clear that you look at how you're going to get out of your business at the end of it. Yeah. And to do that, when you come to that end process, you know, your person who's buying you is going to go through a due diligence stage with you. And that really means he's going to go and look at everything you've done in that business. He's going to look at your contracts, because that's where your value is. He's going to look at your IP, which is where Mark's going to come up to later. He's going to look at the structure of your business, and he's looking at your shareholders and everything else to find out whether there's been any disputes and whether there's anything going on in the business where, you know, there could be a lot of liability in there. So those contracts that at the beginning of forming a business, you might think, oh, it's not worth it, I can't do it, it's too expensive, could be the things that at the end of the day, someone like me or Erika comes along at when you come to sell your business and goes, take a retention off, we'll drop £1 million off of that, because basically these contracts don't exist and there could be liability on it. So, you know, the things you do now will affect the things that you do when you come to sell this business. Sorry, Mark, over to you, mate.
No need for apologies there, Bob. I think you've added some excellent points. And one I'd pick up on straight away is that, you know, it's really good to start with your end game in mind. And that means, of course, that you need to have an understanding of what your exit strategy is, as Bob said, so that how you're going to realize all this investment that you've put into the company, and also your business partners, your shareholders, have put into the company. And this is where IP is extremely important. Often small companies are creating a niche for themselves because they've got something new. They've got something to sell in terms of their ideas, not just the idea they have on the table at the moment, but their innovation generation engine, which means the people, what's between their ears in terms of ideas generation, and maybe the processes that the company has already put into place that mean there's going to be even more innovation going ahead. So it's really important right from the beginning to understand what the value of the existing ideas are in the company. And that value needs to be reflected, of course, in the value of the company. Now, there's only one way to do that, really, and that's to audit your IPs from the beginning, understand what you have, and as Erika referred to earlier, you need to invest in your legal structure in order to understand and set out what you have. So what she's referring to partly there is understanding what your IP is, your intellectual property, auditing it, setting out what it is, what it relates to, what its value is, so that you can then translate that into contracts you have with your shareholders, for instance, and of course with the people you're selling your products on to. It's a huge area, IPR, intellectual property rights, and it covers lots of different intellectual properties. So I'll just take a moment just to very, very quickly list what some of them are, because they may touch on those that are listening in different ways. You know, one of the most obvious is trademarks. We're all very familiar with those because when you go into the supermarket and buy something, we see the logos of things that we buy on the supermarket shelves or whatever. Then you've got copyrights, which is the right to protect the idea that you've put into some kind of expression for something you've created that is expressed in writing somewhere, for instance, like a play. You've also got rights to prevent passing off. In other words, preventing someone from using the goodwill you've created in a product and pretending that they've created something similar. That can be protected. You've also got a right of confidence, and this is something that's not mentioned very often, but is extremely important. We're all very familiar with NDAs, non-disclosure agreements, and we rely on them. And that's just part of what we call in the UK the law of confidence. You have a right as a company owner to protect your trade secrets, and that goes to your employees if you have them, your business partners, and of course people on the other side of the transaction who you may have disclosed something to, but you want to make sure that they do not disclose it elsewhere. There is a law to protect that situation. It's the law of confidence, and that's not to be ignored. You've also got patents, of course, and we're all familiar with those, patents that protect ideas that are put into industrial exploitation. And you've got design registrations and unregistered designs as well. So you can already see in that list, there's a lot of coexisting IPRs that may exist in the company. Now, obviously, there's a lot of complexity to each one of those. It's not really the place on this call to go into all of them. But what we can talk about, I think, usefully is what are the practical steps that new business owners or existing startups and SMEs can do right now to, as Erika said, invest in their legal structure. Now, you're obviously pretty switched on people already, because you're looking into the Zegal software to get really cost-effective templates that will allow you to get clarity around your business straight away. Where we step in, of course, is to be able to, as Amanda pointed to, add some specificity to those legal templates, so that we can make sure that they are right for your company. So in the context of IPRs, that means we can make sure that your templates you're going to use are right for the intellectual property strategy that you are implementing in your company. Now, I say implementing your intellectual property strategy, and it sounds quite big and formal, but actually it's just common sense, isn't it? If you're going to have intellectual property, you need to understand from the beginning how you are going to exploit it, how you are going to take it to market, how it's going to compete with your competitors out there, and how, when you apply it to your exit strategy, you're going to make sure that it gains the value that you intended to. Okay, so just on that strategy, I'd just raise a few points that I think you can think about doing right now if you haven't already done it. Make sure that your intellectual property rights are known to you. You need to document what you have and understand whether you can protect them. And protection is something that obviously depending on what you have. You need to assess how you can use those IPs to attract investment. That's what you're doing. And again, that refers to what Erika and Amanda were talking about, how to capitalize on the IPs. Then you also need to use that IP over the course of the life of your company to ensure that you are exploiting it properly. So just very briefly, if we could use a scenario to explain what I mean by that, by using your IP over the course of the life of your company. If, for instance, a creative person has drafted a screenplay that they want to turn into a film. Once they've drafted that screenplay, immediately it's copyrighted. You don't have to register the copyright in order for it to exist. As soon as you've created it and it's in writing, it exists. But it's still a good idea to actually have something that shows when you created it, so that you can bring evidence forward as to when it was created, to show that you created it before, let's say, a potential plagiarist tries to copy it. Then you may have that screenplay produced on the stage as a play, and it's performed. Again, there's copyright for the screenplay, and there will be performance rights for the performers who performed in that play. Those can be protected. And when that screenplay and play are turned into an actual film, the film itself gets protected. And so you will need to protect that film as an actual product. So, it's an example of how something that starts as a creation in one way and is protected in a particular way, in this case it was copyright, transforms through the life of its exploitation into being protected in a different way as a film, as a product. Hopefully that gives you an idea of the fact that IPRs are coexisting. They are multifaceted, and it's really important to look at your specific IPRs to know how best to protect them. But if there's one thing I'd like you to take away from this, is that you need to always ensure that you have documented what you have, so that if there's any dispute in the future as to whether you created something, you can show that you created it and when you created it. That's quite a long introduction, but I'll hand over now to Dan.
I'm going to cut you. I'm going to cut you there, Mark, because we're taking more than our fair share of time. Thank you very much. It actually goes nicely with a few questions I've had on the side here. Ollie said, when helping 3+-year-old startups, what's the most common thing or process that they've skipped or omitted, which makes you roll your eyes? So on this one, you've got 10 seconds each to answer this. I'm assuming that you're going to say they didn't register their IP marks. So we're going to skip straight from you on to Amanda. Amanda, what's the thing that makes you roll your eyes when you meet a 3-year-old startup? The 3-year-old company, by the way, not a 3-year-old, and who is a startup.
So I think probably the thing that I would say is NDAs. So non-disclosure agreements, confidentiality agreements, call them what you like. People seem to gloss over these, but they're really, really important to make sure that before you start having conversations with prospective customers, suppliers, whoever they are, put an NDA in place. It may also be, the other thing that we struggle with a lot is if you've been using third parties to assist you with developing some software, writing some code, make sure that you've got the ownership of that code and that it belongs to you and that you've protected yourself sufficiently, because you can't claw it back after the event. So NDAs up front, first thing that you should do all the time, every time. We see that people just forget to do it, gloss over it. Massively important.
Thank you very much. Erika? By the way, that was massively more than 10 seconds. So this is a concept that lawyers don't have is time, isn't it? What makes you roll your eyes about lawyers? They speak way more than the allotted time.
You don't know how to count, Daniel. That's the thing. We can't count. So 10-second for me is GDPR. If you are sharing data with third-party processors to help you deliver your services or your products, tell those suppliers what they have to do for you to manage your data. Your data is a massive asset that will cost you lots of money if you don't protect it. I think
I'm going to come back to that because I think we're all interested in understanding GDPR and whether it still exists and all that good stuff. I'll come back to that shortly. Actually.
Sure.
Robert?
Yeah, basically, I'm going back on the sort of like the Amanda bit and the Mark bit and everything else. I think you need to, in your negotiations throughout your contracts, you need to, number one, make sure your IPR is protected in your contract. More importantly than that, you may need to make sure that when you're negotiating it, you don't give away the baby with the bathwater. I've done some litigations for major software companies that have made mistakes on an IPR clause. They've given away the IPR and they have paid in millions of dollars. Yeah, and you can do that. If you do that, it wipes your business off the face of the earth. You need to protect it in contract every time.
Wow, I'm going to pause just for dramatic effect because that felt like a lot going on in 10 seconds. I'm worried myself.
I think it might have been 12 there, Mark.
Yeah, I'm worried myself. Erika, I'm going to come back because one of the things I wanted to talk about is startups that we talked before. Actually, I think it was Amanda that mentioned, so much of what's being done in the UK in particular is service driven and technology driven, and many of the businesses that we see are sort of platform based and have aspiration to sell not just in the UK but to sell overseas quite quickly as well. And I wanted to just get your thoughts. I might start with you, Erika, if it's okay. Your thoughts on what are some of the things that we should be thinking about, I guess, when we start that process. I think there was a belief up until quite recently that we could just set up a platform and go. Of course, laws have changed quite substantially over the last few years in Europe at least, to try and stop folks from doing that in some respects. So if you could give us maybe a little summary of where we stand now as a new business who's setting up a platform and what are the things that we might want to worry about specifically in that space.
Don't be frozen, Erika.
Erika's either just horrified by the question or she's frozen. I'm gonna skip off Erika and I'm gonna take whoever else wants to answer that question.
Go for it, man. Man, did you want to answer that? Oh,
Erika's
back. There you go.
Sorry.
Erika, I thought you were terrified by the question, so shall I quickly recap it for you? Platforms. What are the legal concerns?
Every time someone asks me a question on a panel, it freezes. I think it's trying to help me out. Yeah, never on my good side. So I think what I'd like to do is just focus very briefly on the data side of that, and then I'm going to hand over to Amanda to deal with the contractual side of that. From a data perspective, it's really, really important you consider who you're selling to and where, because Daniel, you alluded to a question earlier as to whether or not GDPR still exists, and it absolutely does. But there have been some changes following the exit agreement, following Brexit on the 31st of December. So if you're setting up a platform that's going to be offered in multiple jurisdictions, you have to firstly consider what those jurisdictions are going to be and what laws apply to your platform. Because although you might be a UK-based company that's governed by UK law, you might also be touching on other laws in other countries where your consumers are. And particularly in Europe, if you are dealing with consumers in a European country, as a consumer, their local law applies to them.
And hosting is the other thing that I bring in there just to cover up while Erika's frozen again. But obviously, where the servers are hosted plays an important part of that as well. And I'm now going to hand back to Amanda. Go for it, Amanda.
Yeah, no, I was going to pick up that exact same point about the hosting. And, you know, a lot of people are using the same centralized hosting services. So Microsoft Azure as one example. And, you know, where those servers sit and access to audit rights and provisioning around that are all very strictly controlled. So from a confidentiality perspective, often we don't even know where those data centers are. And so it's important that all of that's disclosed and all of that is understood and managed effectively. So, you know, I think the other point to note is around, you know, the structure of how you're going to license whatever it is that you're pushing out on the platform. So, you know, there's an opportunity to restrict or control the revenues that you get from that around the licensing provisioning. And how easy is it for you to terminate that license remotely if somebody's using it inappropriately? There's lots of legislation in different parts of the world around the content that can be pushed. And, you know, some of that's religion based, some of that's cultural based. And so it's, you know, and some of that can be extremely sensitive, and the consequences of getting that wrong, you know, can be really quite severe, and things that we may take for granted, you know, don't necessarily replicate in countries across the rest of the world. So be mindful of that, make sure that all of that gets checked out first. As I say, it's very, very easy to push the content and then, you know, be dealing with the consequences afterwards. So find out in advance. And if you've got an opportunity to build in some gateways within your software offering that restrict users, that allow you remote control, that allow you some form of screening or audit around that content, then I would strongly advise, you know, you getting the software development guys to build that in so that you've got more control over that usage locally. I didn't know if you wanted to add anything, Erika. I believe you're back with us.
I know, I'm so sorry. I don't know what's happening this afternoon. Well, another point I'd like to make actually, and thank you, Amanda, is accessibility. So there's lots of differentiating rules around the world on your platforms and websites in particular being made available to people that are considered to have and it's really important that you comply with those laws, particularly in the US, where the sanctions are really quite financially impactful. So please always think about that as well. I think the key message here has to be, if you're selling or you're hosting in other jurisdictions, in other countries, think really clearly about where they are, what percentage of your business comes from each country, and therefore what impact in terms of risk that has on your business, and work backwards from that point. So you can say, if a big part of my business is in the US, that's where I'll focus my time as a priority to get the legals right, and then move around accordingly based on the market share in each country.
Really useful advice. Yeah.
And don't forget that in the States, it's state for state and not any other way. So it really does make a difference.
Yeah.
I'm going to switch topic again very, very quickly. So I see that we're running out of time. We're going to get told off by by the Purposeful Project soon for taking more than our allotted share. But no discussion of startups would be a full discussion unless we talk about money, seeing that most startups are continuously voracious to get more of it. I think it's a topic in itself, and we shouldn't try and delve too deeply and too broadly, especially when we've only got a few minutes left. What I'll do is I'll focus on one of the questions that we got from our attendees today, and they had a really interesting question, I think, because it doesn't talk so much about the ways in which we sort of think about getting money and the different types and ways you can do that. It's actually quite a specific point that a lot of founders, I think, have as an issue, which is how do they actually value their own time? So, you know, a lot of startup founders might not be taking salaries, might be raising money, might be thinking about paying themselves less than perhaps market rate, or indeed paying their team perhaps less, or indeed more, thinking about giving them shares. There's lots of different ways in which this can be done, and there's all sorts of clever things like slicing the pie, or there's just, you know, sticking your finger in the air, there's working out, you know, market rates. What does this panel think makes most sense in the current environment, and how should founders be thinking about their value as regards raising money and the value that they put back into the business?
Well, what I'd like to say there on one thing, from having done it a few times now, is that don't make mistakes in the early stages of turning around and saying, I'm going to give away a large chunk of equity, or even a significant chunk of equity, to an individual before he's actually started to perform. So you need to make sure that if you're going to give it away to individuals in your team because you think they're going to be useful contributors to what you're producing, then incentivize them to make sure that they actually produce before you give them that equity stake. And there's loads of ways of doing that. You can put schemes in place, employee schemes in place, and you can even roll it to consultants if you're going to bring them in that way. So I'd look at the way of structuring that so you can incentivize them when they've actually done the job.
Mark, we've not heard you from a little while. I'm feeling that you've chastised by me earlier on, so I'm making a point. Mark, please tell us.
Yeah, I was still thinking that my 10 minutes were up, Daniel, so I wasn't going to say anything.
Yeah, Mark, there you go.
No, very good points already made there by Erika, Amanda, and Bob on making sure that you can keep control is the essential thing. I mean, I'm reminded of something I've worked on recently in the fintech area, where someone came in, thought that they could provide a certain amount of expertise and connections, but couldn't in the end. And this particular person was pushing this startup to give them a contract that would mean that they would get a lot of upfront payment. And I was the guy in the room saying, no way. And it turned out to be, of course, very good advice, because that individual could not actually provide the connections and the input that they thought. So control, and yes, not giving away any equity until you really need to.
I think one thing I'd like to add to that, I mean, I know lots of people raise their initial cash from friends and family and stuff like that, and they don't document it because they think it's going to be the best, you know, it's a family relationship, and they don't document anything at all. I have seen some severe problems come out of friends and family relationships where they've put money into a business. Everyone on the call is nodding now, yeah, where they've put money into a relationship, it's not been documented, and all of a sudden the company's worth a fortune, and the person who's put £2.50 in now wants a huge part of that, because basically, and the relationship's broken down, they don't talk it to anyone anymore, and basically it all ends up back at the litigator's door, and it costs a fortune. So document it. Even if it's on a piece of paper that you keep in the drawer, document it.
I completely agree with that. And I'd like to make just one or 2 points here. The first is that when it comes to money, just to reinforce Bob's point, people will sell their grandmother. Between us here, we've probably got, 100 years worth of legal experience. So I'm sure we can all tell stories on another day of some of the awful situations that we've seen. But it's so important to determine what your value is in your head. Don't undersell yourself. We've all seen Dragon's Den. Know exactly in your head what you want and where you want to go with your business, because that will drive your focus to the right number. The reality is that there is no magic formula. The magic formula is dependent on your business. but you are credible, you have a great business, you've got it to where it is. Don't ever undervalue yourself. Know what you...
It's happened again, hasn't it? I think the other thing is don't overvalue yourself. Make sure that you're being realistic in what you're providing. Yeah. Sorry, Erika. I just infilled there while you froze. Bit of improvisation. Sorry.
I feel every time that you're about to make a nice pithy Instagrammable statement, you get frozen. It's very unfortunate.
I know, it's very annoying, isn't it? No, I was just saying, at the end of the day, you've got a credible business. You don't want your business to burn you out. So it's really important that you know where you're going and what you want to achieve out of your business, and you stand fast on that and you stay focused, because you will get it and you will find the right investor. And, you know, I think we're all entrepreneurs here. You have to stick to your guns and you have to focus on your end goal. And that will drive you into finding the right people and putting the right processes and the right documents in place. But take advice, because that transcends everything we've discussed here today. It's really key. But know your worth. Yeah,
I agree. It is a case of get advice, get it as cost effectively as you can. A bit of promotion coming up here, Daniel. But it, you know, we in the UK, you knew it was going to come. Yeah, we charge 155 an hour for our lawyers in the UK, so you can get advice cost effectively. And you know, don't just think that sometimes it's not worth it, because in lots of occasions, you know, that one bit of advice that hopefully you've picked up something this afternoon from this call that we're on, just one bit of advice is enough to make you a load of money down the road throughout your business, and to keep your business on track and secure, and make sure you're not giving away baby with bathwater.
Absolutely. And one of the benefits of, you know, coming to an organization like ours, as Erika said, just with the 4 of us here, we've got over 100 years of experience. Learn from somebody else's mistakes. Don't learn from your own mistakes.
Are you inferring that I've got 80 years and I've only got a small bit between you?
Yeah. Lots of moisturizer. That's all it is.
See, lawyers even have humour. Carry on, Daniel. Sorry.
We've got a few minutes left still. We managed to cover quite a lot of ground, didn't we? We had one other question actually from one of the attendees. I think actually it covered something that Amanda, that you touched upon in the start of the call, which is the sort of feeling that it's a bit David and Goliath out there, and that oftentimes we set up a new company, and maybe we've come from a bigger company in the past, and we're used to having, getting on the phone call and the brand speaks to it straight away, and the way we're dealt with in one way, and suddenly the very same human being switches onto another meeting with a non-brand and gets trampled all over. How do we avoid that situation where we send out our contract, they ignore it, cross it out, and send back a much longer one, and then start negotiating that? Or can we not avoid that? Do we need to just think about ways of maybe accommodating that fact? Perhaps you know that, Amanda.
Yeah, no, it's a great question. And actually, I would just rephrase the question slightly. So you were saying, we put our contract out there and they redline all over it, stamp all over it, and push theirs. I think that what we find a lot of the time is with startups and SMEs, they're scared to put their contract forward. And sales guys think that it's a really negative thing to do, and they leave it till the last possible moment. That's where the wheels come off the bus. Lead with it, be proud of it, actually stand by what you believe in, which is what, a lot of this messaging is about. And actually, you're there because you're unique and you're special and you've got something they want. Don't forget that. They're coming to you because they want what you've got. So protect it, lead with it, be proud of it, and actually say you want it. These are the terms that you can have it. And
Amanda is my lawyer.
and get someone in like Amanda that can actually understands the points of what they're trying to do, because many times they're going to be pulling the wool over your eyes. They're going to try and get hold of Mark's IP. They're going to try and make your liability through the roof. They're going to try all the underhanded, nasty things that lawyers actually do. So get someone like Mandarin to actually fight that corner. She's done it thousands of times before because she's 50 odd years in the profession.
I'm pausing you, Robert. There's enough sales going on. We haven't got time. We get it. Amanda's really good. Funnily enough, actually, we've had one last question, which I think is always nice to end on a question like this because it'll make you guys all laugh. It says, what are the recommendations for identifying a trustworthy lawyer to partner with? Which made me laugh when I saw the question. But I'm going to point this one to Mark, simply because actually Mark made a really interesting observation before when he said that, that he'd worked with a startup and they were getting pushback from probably a trusted advisor. That advisor couldn't deliver the value. And we see that time and time again, right? We as lawyers are advisors. There are lots of advisors advising lots of things. How do we get the right advisor? That's a bit tricky, is it not? What do we think we need to be looking out for in the legal profession for people that are going to add value?
Well, thanks for the question. Look, as a startup, as a small company, for any company really, you want cost-effective legal advice. You need to research what your lawyers provide. It's very good to go to a firm that can provide the whole suite of advice, because even if you only want to get advice on a particular area, if that firm can call upon within its cohort, within its set of lawyers, advice in all different kinds of sectors, you know that they have backup. So cost effective and a legal team that can cover you from start to finish. Hope that helps.
There's me speaking on mute. I think that's probably a nice ending to the piece, if you don't mind. We are 5 minutes early, and I saw a post that was circulating around LinkedIn this week where a sales director stopped an hour-long meeting at 58 minutes and gave 2 minutes back to his team. I wasn't sure whether it was tongue-in-cheek, a piss take, offensive, or a good thing. I still don't. I'm obviously too old to understand humor. But anyway, we're giving 5 minutes back to those people who haven't eaten their lunch at this point. Thank you all so incredibly much for taking your time today to give it back to us and to everybody who is benefiting from the work that Purposeful Project's doing to help 1 million startups in a very short amount of time. Thank you, Talia, for hosting us. And that's us, I think, for today, unless you've got anything else that you'd like to wrap up with, 360 team.
No, just thanks very much for inviting us along. I think it's been brilliant and we enjoyed it.
Wonderful.
And good luck with your businesses.
Yeah, indeed.
Yeah, very good luck.
Thanks, Mark. Thanks, Robert. Thanks, Amanda. And thanks, Erika. Hopefully you're with us, Erika, because you're still quite still. Whenever you go still, you wobble the whole time to prove that you're there. Wonderful. Thank you very much.
Finally.
Thanks. Bye-bye.
Thanks, guys.
Thank you.
Bye-bye.
Bye-bye.